歡迎。Welcome to the 60th meeting of the Bills Committee members. There's a one item under matters arising carry forward from the last meeting, and that is we are going to vote on a request made by Dr. Kwok Ka-Kay on whether we shall prepare verbatim transcript for the meeting on the 17th of May, 2019. So this is a vote on the request to make verbatim transcription. So you please press the button to register your presence, and then you should vote. I was on my way when you make the announcement. I didn't hear quite clear what you were talking about. Can you please repeat it? Mr. Tam, next time please be punctual. Last time I said that at the beginning of today's meeting, we are going to vote on Dr. Kwok Ka-Kay's request. That is to prepare the verbatim transcript for the proceedings today. Some said yes, some said no. I need a decision taken by the whole Bills Committee. The general rule is that we won't do it. Please press the button to indicate your presence, and then you can press the button to indicate your vote. Before I announce the result, please check your vote. Voting is now closed, and the result is displayed. 29 present, 6 for, 22 against. I declare that this request is vetoed. Ms. Quatermo, is it a point of order? Yes. This is on the morning of Saturday. You suddenly make the change. It was in the afternoon in the first announcement. Well, many pandemics have had already made arrangements to visit prisons at that point. So why suddenly make a change? Is it that you are concerned that the Western District will be most upset? Well, I think this would be more convenient because usually people would have to do something else in the afternoon. So you thought that we are going to consider the Fugitive Offenders Amendment Bill? That never occurred to me. Welcome to I have already responded to that issue. It didn't come into my consideration. Or perhaps Mr. Charles Moore, you can also raise your question first. As Ms. Claudia Moore has said, at first you make an arrangement, and we have make our arrangements to such as Mr. Yip Kyun Yin and I have made an arrangement to visit the prisons, and I hope next time if you make such a you should avoid making such last-minute changes. And you should at least consult members. Don't think that you are in the majority and you can do whatever you want. Ms. Claudia Moore, when I talk to you, my mic was not switched on. Are you concerned that you would insult the Western District, or that the Western District would be upset, very upset? The answer is no. Why did you say that? This is not a point of order. I can give you an answer later. I will talk to you later. Don't waste our meeting time. Last time, Ms. Claudia Mode pressed the button and wanted to ask some questions. Members who haven't done so, please do so quickly. Ms. Claudia Mode, 2 minutes. Thank you. Clause 11, subsection 2. The Chinese version is puzzling. The English version, it has one additional word. The Chinese version is 並如此實施 or applied.
Interpreted 嘅中文冇呢個意思嘅喎，你呢
Why do you have this word interpreted? It's not in the Chinese version. Are you talking about an interpretation, an understanding, or based on? This bill seems to have a problem with inconsistency between the Chinese and English version. I didn't ask this question last time. Interpreted. I never asked any question on the word interpreted. I wasn't at the meeting. Well, the Deputy Secretary said it was asked. The English is this ordinance to be interpreted and applied. There are two verbs. And the Chinese version 本誰來須解釋, which means that the ordinance is to be interpreted. And 並如此實施 in the Chinese version means as applied. And well, I thought you would have said this interpreted is not just about an explanation. Why don't you use another Chinese term, 詮釋, instead of the 解釋 for interpreter? Well, in this context, it's correct to render it as 解釋 in Chinese or interpreted in Chinese. Ms. Jeremy Tam. Clause 11. National anthem law means the law passed on the 1st of September 2017 at the 29th meeting of the Standing Committee of the 12 MPC. If in the future there are amendments to the national anthem law, would it mean that we are going to make consequential changes? As I've said, this is under a master script. You are only going to follow the script. If the master script is changed, or in the mainland they have a version 2.0, then there will be a problem with the entire clause 11. Because you have been referring to version 1.0, not 2.0. So I believe when that happens, you have to amend clause 11 here, and the objective to be served by clause 11 will be lost, because there will be a version 2.0, and we are talking about version 1.0, and then there will be a vacuum. Or what would you do to handle the problem in the interim? Well, this is a question that sounds familiar. Yesterday, we answered a similar question. First of all, that we have to act in accordance with Article 18 of the Basic Law in respect of national laws. That is to say, the law will have to be put into Schedule 3, and then we will have to decide whether we need to amend our local legislation, i.e., the national anthem bill that we are now considering. Mr. Alvin Young, the Supreme People's Court has the right to do the judicial interpretation on of mainland laws, on the interpretation and also the interpretation of legal provisions arising from cases, judgment cases. If there is any judicial interpretation in the future that would affect the meaning of the national law in some way, would there be any implication for our local national anthem ordinance? What would the Bureau do to dovetail our law with the mainland? And how do we make sure that our understanding is a compatible one? I cannot speculate. About the way or the content of any judicial interpretation that may happen in respect of the national anthem law. So I can only speak from principle. That is to say, we have to comply with Article 18 of the Basic Law. That's the mechanism of incorporation of a national law in Schedule 3. We cannot just rely on a judicial interpretation to trigger some action. So that's how we would deal with Article 11. I hope that the Permanent Secretary can elaborate on his answer. The judicial interpretation in the mainland is just like the judgment delivered by the Court of Final Appeal in Hong Kong. It's binding. Of course, we cannot copy word for word the judicial interpretation into our local legislation, but it's because of the authority of the judicial interpretation. What would the Bureau do? For example, would you bring it up for discussion at a panel or something else, or you would do nothing? Judicial interpretation in the mainland is kept a separate issue, and we just work under our system. I just want to say that if there's anything that is not that's not based on Article 18 of the Basic Law, that would not affect our national anthem ordinance. If we would have to introduce legislative amendments, of course, we have to come back to the Council.
If there is a judicial interpretation, would the Bureau submit that interpretation to LegCo so that we could be informed? Chairman, if LegCo indicates an interest or if the relevant panel is interested, and if we receive any such information, of course, we will be happy to relay them to the Council. I also like to remind members that Section 11, Part 5 are just supplementary provisions. There are only two substantive, content. First of all, that is, should there be any breach of the national anthem ordinance in future, then we would conduct investigation and prosecute according to the laws of Hong Kong. The second substantive provision is that if this provision, is not consistent with the national anthem law, then the local legislation should prevail. So I thought that this is not controversial, but never mind. We've spent more than 2 hours discussing this point. I hope members can have a better grasp of the issue and do not repeat the points which have already been covered, because this is a more controversial, clause. Mr. Wuu Chi-wai, I understand that whether it's Section 1, Bracket 1, Section 11, Bracket 1 and 2, members we didn't have too much, controversies, but instead there were many members were not very clear about subsection 2, and they were asking the PS to explain. I also asked my question yesterday, and I heard the law draftsman and the PS giving a detailed explanation. I don't know whether my understanding is correct, and I'd like the two gentlemen to further elaborate. Subsection 2 says that we need to enact a piece of local legislation. So the content of the bill, if it should contradict or if it's not consistent with the national anthem law, then the content of this bill is equivalent to is an adaptation, a special edition of the national anthem law. If that's the case, as I said yesterday, if the legal provisions could be spelled out more clearly so that one could easily understand, that would be preferable. So I'd like to ask the PS and the law draftsman to tell us whether or not the wording or the text of this provision should be made clearer. Do you have any suggestions? For example, you said this ordinance. I think instead of saying this ordinance, I think you should say the content of this ordinance, or you could say the meaning or the purpose of this ordinance. If you specify that you're referring to the content of the ordinance, if it does not, correspond to the content of the national anthem, then this would be regarded or deemed or construed to be a special adaptation of the national anthem law, and hence. We will implement that based on the content of the local, ordinance. I just made this point, but I didn't understand this point last time, and I asked the law draftsman the same, because I think your point is clear. Of course, I did not put my question down in writing, but I was just asking whether or not this section could be, drafted in the manner which I suggested, because if the government were to adopt this, style of drafting, it will be more comprehensible. I think we've answered the same question yesterday. I'm not asking you to, clarify what I'm saying. I wonder whether or not you can implement, what I suggested. Thank you, Mr. Leung. I think our drafting is based on the same, is the same as, Section 9. So we hope that both consistent, clauses should be consistent. Dr. Cheng Chung Tai. Thank you. I don't know whether this point has been raised yesterday or not, because there were 4 meetings held concurrently yesterday. Now, Section 11 is a supplementary provision. It's not very controversial. Furthermore, in the national flag and national, and emblem law, there are similar arrangements. Comparing the two, my question is that in terms of the wording, you have a different description of the Hong Kong SAR. In the national flag and national anthem emblem ordinance, it's the offense in respect of the contravention of the national flag and national emblem law. We will conduct investigation and prosecute based on the Hong Kong ordinance. Whereas for the national anthem law, you say that you will do it in Hong Kong in accordance with the laws of Hong Kong. If it's the same, why is it that for the national anthem, bill, you did not say that in Hong Kong instead? I think in Cap 1, there is an interpretation of the Hong Kong SAR. During the adaptation, this was only added in 1998 when the ordinance was adapted. So the objective fact is that in 1997, when we dealt with the national flag and national emblem ordinance, we did not have this, definition, and that's why we have the long version, which is the Hong Kong SAR. But now we've using Hong Kong in this context can resolve the problem. Now, if that's the case, you've already defined Hong Kong, that is, in the law. Why is it that in subsection 2, that is, in the National Flag Ordinance, you say this provision is based on Annex 3 of the Basic Law. But here you say specifically that if this ordinance is inconsistent with the National Anthem law. I think that's the same question raised by Eddie G yesterday. I think the National Anthem bill is, is meant for us to enact the local legislation to implement the National Anthem law. Now, at the moment when the SAR was set up, the National Flag and National Anthem law was enacted, and the bill at the time, the wording used was refer to the Basic Law and the national laws. Now, in Annex 3, when did we add the National Flag and National Anthem law? It was only added in 1997. So objectively, it might have been that when the National Flag and National Anthem law was being drafted in Annex 3, we didn't yet have those ordinances. So whereas now in Annex 3, we already have the National Anthem law, and that's why we have specifically spelled out the National Anthem law here. Well, I was attending another meeting yesterday. Yeah, I've checked and I and the same point has been asked yesterday already. Mr. Yu Chong, I'd like to ask a similar question as that posed by Dr. Chang. The law draftsman said that we need to be compatible with the National Anthem law in order to avoid any misunderstanding or controversies. But in Section 9 of the National Flag and National Emblem law, I think I can better understand the content. It's that this section, is referenced. It refers to, Schedule 3 of the Basic Law. And we're talking about the content. But here you said this section and the National Anthem, we don't know what it is. Are we talking about the purpose or the meaning or the effect? So I always think, perhaps our legal advisor can also explain. If we're talking about the content of this bill, if it is inconsistent with the content of the National Anthem law, wouldn't that be clearer? I think your point has been made clearly. You'd like to follow up on the previous question you asked? I think this is a follow-up to a question raised at the last meeting. I'd like to thank Mr. Leung for his suggestion. I know that this provision is, the subject matter is that this it says that this section should be interpreted and applied as a special application or adaptation of the National Anthem law. We're talking about the content and not the purpose. Otherwise, we don't need to deal with the interpretation and the application. Only when the contents are not the same that we need to deal with the question of interpretation and application or adaptation. I have a question in respect of Section 11, bracket 3. Some questions asked another question regarding amendment. I'd like to also make some suggestions regarding amendments. After the MPC has made the amendment, and when we have a new national anthem, then it will become a national law, and then we can expand the scope or occasions where the national anthem will need to be sung. So there may be a time gap here. But can we use, by way of notice, amend the schedule so that the amended content could be more expediently incorporated into the bill, because the two methods of amendments are different. If we only apply 5(2), you would do so by way of a notice, whereas if you want to amend Section 11(3), then we have to go through the first, second, and third reading process. Now, if in the mainland they've amended the national law, I think the same question has been raised already. We're now looking at Section 11. I'm talking about the method of amendment. I think Section 11 is a supplementary provision. It's not about amendment, but never mind. I will still exercise my discretion and allow your question. Chairman. We're talking about the mechanism for the amendment of the content of the national anthem upon the enactment of the bill. Ms. Priscilla Leung, thank you. I would also like to ask a question relating to Section 11. There are only two ways to adopt the national law, anthem law in Hong Kong, either by direct proclamation, and it doesn't have to go through the third readings in this council. For the national flag and national anthem law, we adopted the local legislation approach. Ms. Leung, I think we are scrutinizing Section 11. Yes, indeed. I think you added Section 11(2). You've tried to actually incorporate the jurisprudence into the provision. I wonder whether Hong Kong has the authority to use an adapted version of the national anthem. In legal theory, it's clear. The Hong Kong National Anthem Ordinance must be consistent with the national anthem law. In which area, I think where there could be any inconsistency will be in respect of the technical issues. For example, in Section 14, which doesn't apply to Hong Kong, it's not applicable to Hong Kong. But in Section 15, as Mr. Elvin Young said, if there is a judicial interpretation in the mainland, or if there is an amendment to the national anthem law, and you change the word distortion, I think Section 15, I think the main, offences should be consistent, except for terminologies like, public security officers, which we don't have in Hong Kong. So there's a need for adaptation. It's not that, so we have to actually, discharge our responsibilities according to the basic law. But in the course of adaptation, we have to consider the local legal system, the local culture, and make appropriate amendments or changes. You say that this is the adapted version, and I don't think that is right. And you are trying to incorporate the legal theory into Section 11(2). I just like to bring out this point is wrong, and I think colleagues have asked a very good question. You should go back and consider whether you should draft this subsection in this manner. We're not looking at an adapted version of the national anthem. We're just exercising our duty pursuant to Section 3 and Schedule 3 and Section 18 of the Basic Law, and we've adopted the second approach. If they change one word in the national, and then we have to amend our national anthem ordinance. But as to how the court in Hong Kong will deal with this, the Hong Kong court will, judge whether or not there is any distortion based on the common law system. So we can also, apply the common law defense. So by the benefit of, using local legislation to do this is that we can use the local legal system, to make a judgment, and the act may not be an offense in Hong Kong. So I don't think it's adaptation. I think subsection 2 actually is a bit redundant. So 2 questions. Section 11 bracket 2, is it redundant? And secondly, is the wording adaptation not right? I think we've made reference of section 9 bracket 2 of the National Flag and Emblem Law, and we've adopted the same wording. At the time of the drafting, we felt that we need to retain this for the sake of certainty. Ms. Leung, I think you need to press a button again. Dr. Cheng Chung Tai, 2 minutes. Chairman. I'd like to follow up on Priscilla Leung's point, and I asked the same question yesterday, but I did not have the legal background. That is, when the National Flag and National Anthem law was, being drafted, we were during the transitional period, and there was no specific National Anthem law or National Flag, law as a basis. So in the National Flag Ordinance, you have Section 9 bracket 2. The original ordinance, if it is inconsistent with the national laws in the mainland, and then you have the wording adapted version. And referencing that of the legal law draftsman point earlier, the PRC's National Anthem law has already been adopted and implemented. In 11 bracket 2, if we use an adapted version, like Ms. Leung said, you don't need to draft this subsection in this way, because 9 bracket 2 is not about the National Flag or National Anthem law. If 11 bracket 2 is so specific, that is, if there's inconsistency with the National Anthem law, I think do you need to, draft this subsection in this manner? I think the background here is that the purpose of the National Anthem bill is to implement the National Anthem law. And if there is any discrepancy between the bill and the National Anthem law, for example, in the National Anthem law, if some of the provisions are not implemented in a bill, or if there's any changes in the course of implementation, how do we see how should we interpret the Hong Kong National Anthem interpretation? What we're saying is that when we make the interpretation, we will deal with it as if it were, an adapted version. We're not trying to explain that all these changes are appropriate. Of course, the Bills Committee had tried to explain why we've.
Well, can you give me 10 more seconds? I'm not going to follow up anymore after this. No, I don't think there's enough time. Please press for another round. Dr. Priscilla Leung. Chairman, well, I can accept as a special application, but for the term adaptation, I think that we can discuss this further, because our original intention is to have it applied as a special application. Therefore, we are not setting an adaptation of the National Anthem law. Instead, it's just that we are making certain adaptations to the local area. So basically, we need to be consistent with the National Anthem law because we are executing and implementing the National Anthem law. We are not making changes to it. So it should be applied as a special application. As to non-permissible behavior, then we should be consistent with the National Anthem law. Because this is a consistent content across the board, I feel uncomfortable about it. I do not mind the term special application, but I am quite uncomfortable with the term adaptation. I just want to make this clear. Thank you for your comment. Perhaps the administration can consider this further, or Dr. Priscilla Leung can move a CSA. Mr. Gary Fan. Thank you, Chairman. We just had a meeting yesterday, and now today we're holding another meeting. You only just informed us 2 days ago that the meeting has been changed from the afternoon to the morning, and I was at a meeting this morning, so I was late coming over. This is really not an ideal situation. I'd like to ask about Clause 11, Bracket 1. Officers in relation to the national anthem in Hong Kong are investigated and persons are prosecuted according to the laws of Hong Kong. Yesterday, I asked the administration about this, and the administration replied that because this has been a reference from the national emblem and flag law, and to ensure that there will not be any controversies over that. Well, can the administration explain what kind of risk there would be if you do not put this under subsection 1? Well, if you do not have this subsection, would the administration believe that there would be some sort of investigation, not in relation to the national anthem offenses? Do you think that if you do not put this down in writing, then people would be prosecuted not according to the laws of Hong Kong? So you think that there is such a risk, and therefore you decided to put this in under Clause 11, Bracket 1? Mr. Tang. Well, actually, I answered this question yesterday already. Once the National Anthem Bill is legislated, as we already in our national flag and emblem bill put this down, we want to make sure that this is also consistent. Because if we do not put this down, then the public may have unnecessary concerns, and therefore we decided to put this down to be consistent with the other laws. I'd like to respond to Mr. Gary Fan's criticism of the changing of the meeting time from the afternoon to the morning. I accept your views because some other members have also commented on this. I thought that everybody would have a busy schedule in the afternoon, and I thought that the morning would be more convenient to all of you. And I want to clarify that we made the change in meeting time on May 15th on Wednesday, but I still receive your views on that. I would make sure that I will notify you early in the future. Mr. Jeremy Tam. Well, you didn't reply to my question that when the mainland makes changes and Hong Kong does not follow, would there be a sort of one less layer of protection for Hong Kong under Clause 11? Well, you cannot say that in 2017 the national anthem law was already passed. No, I mean if there is let's say there is a new national anthem law updated on June 2019, and if no amendments have been made in Hong Kong, then what would happen? Well, let's say that from now till the Chinese government makes changes or amendments to the laws, then what will happen? Because Clause 11 it's protecting this part. Well, there wouldn't actually be a vacuum period, because we will still be only implementing this under the current legislation. Well, I want to say that if you would like to speak, please come down and indicate your wish to speak as soon as possible because I'm going to draw the line in 10 minutes. It's now 9:47. Well, I'll draw the line at 10 to be more precise. Next, Mr. Leung Yu-chung, 1 minute. Chairman, yesterday I said that every word is important in the bill and every word and sentence have its own effect. I just want to ask a simple question. Can we also include the inconsistencies in content in clause 11? Is there a difficulty in adding this to the clause? If it can be done technically, can you consider adding that to the clause? Mr. Tang? Well, we may want to ensure that there is consistency in our legislations, but I would like to defer to the law draftsman on that. Mr. Pang? Well, it's actually similar to the Clause 9 of National Flag and Emblem Law, and therefore if we are inconsistent, there might be many controversies on that. Dr. Priscilla Leung, thank you. Well, I'm still following up on my previous issue. Under Clause 11, bracket 1, it said that persons are investigated and prosecuted according to the laws of Hong Kong. Well, the court, of course, must make sure that cases are dealt with by the common law. If you only put down investigated and prosecuted, would not be enough. Even if you don't put this down in writing, of course, everything would be done in accordance with the laws of Hong Kong. And so I think that if you only put down prosecution here, would the public worry about it? Can you actually clarify it further? I'm not trying to move a CSA here. I just want to say that you only put down prosecution here. You should put down the enforcement of the law should also be in accordance to the laws of Hong Kong. I think it's like that in the national emblem and flag law, because all the court cases should be handled in accordance with the laws of Hong Kong, and I think you should make it clearer here. Thank you for your comment. Next, Ms. Claudia Mo, 1 minute. Thank you, Chairman. Dr. Priscilla Leung's meaning is very clear. I think you should make it clear. Don't say that there's an adaptation of the national anthem law. You do not have the authority to make an adaptation. And she's actually not very happy with the term special application. So, we want to save everyone's face, so you shouldn't just cross it out. But then adaptation is not, adaptation in Chinese, 改編本 is not quite appropriate. Would you consider using the Chinese term 適應本 instead? Well, we actually drew reference from the National Flag and Emblem Law. Dr. Cheng Chong Chai. Well, back to the previous discussion. Well, at that time, we didn't really have the National Flag and Emblem, National Emblem and National Flag law, and now, well, since we didn't have that before, it might be flexible to use the word adaptation before, but now with the national anthem law, I think it's already enough to use a special application. It's already clear in the term special application. I think adaptation is a bit redundant here. Well, I think our discussion on adaptation is quite enough. Perhaps law draftsman. Well, at that time, a national emblem law, national flag law was not in Schedule 3, but then since it's already now included in the Schedule 3 on the same day, actually we're talking about the same thing here. Mr. Gary Fan, I would like the PS to answer the previous question, which is even if we do not put down 11(1) here, there would not be a worry that persons of prosecution not in accordance with the laws of Hong Kong. So you are saying that clause 11(1) is redundant? Yes. Oh, you're just saying that this is inconsistent. The only consideration is that it is inconsistent with the national flag and national emblem ordinance. Well, yes, because we do already have a national flag and national emblem ordinance. If we now do not have the same consistent term here, then the public may have a reasonable doubt on that, and so we want to make it clear that that we are still protecting them with the same clause. Ms. Claudia Mo, clause 11(1), the Chinese saying that there is the offenses 罪行. Well, I really hate the two words 予以, that persons are prosecuted. But in the English, you didn't say that offenses are prosecuted. You said that the persons are prosecuted. But then in Chinese, it's only said that the offenses are prosecuted. But in English, you say that the offenders are prosecuted. So is there any problem by not being consistent in the English and Chinese version? Well, it's actually the same meaning. Because, of course, if there are any offenses, then we prosecute the person. So you shouldn't add the term persons in English because you didn't include that in Chinese, right? Well, the syntax is clearer if you put the term persons. You can't just say offenses are prosecuted. It seems that it's not correct. Well, how about Chinese? Well, the Chinese, it's clear. Dr. Priscilla Leung, thank you. I really just want to go back to reconsider. Well, I think special application of the national anthem law is acceptable. But the Chinese is 改編本. Well, if you want to go back to the old times, well, I wasn't a legislator back then. But I don't mind, the special application of the national anthem law, but I do mind the Chinese term 改編本 because I don't think that's appropriate. Oh, I was also in Black, the Bilingual Law Advisory Committee, but I do want you to go back to reconsider this. Well, maybe you can move in CSA, Dr. Priscilla Leung. Well, since there are no more questions, let's move on to clause 12, 13, 14 on consequential amendments. Ms. Lam, please. Thank you. Part 6 is on consequential amendments, which are clauses 12, 13, and 14. So this would look at the So this is actually amendments to Trademarks Ordinance Cap 559 and actually amendment to Legislation Publication Ordinance Cap 614. The clause 12 is on enactments amended. The enactments specified in divisions 2 and 3 amended as set out in those divisions. And clause 13 actually are amended to ensure that it could be consistent with the national anthem law. And clause 14 also amended section 4 on the contents of database. Mr. Chen Chi-chun, first round 4 minutes. On 13 bracket 3, I see that you suggested adding a national anthem means the national anthem and its lyrics and score within the meaning of the National Anthem Ordinance of 2019 as extended by Section 8 of that ordinance. Well, as you all know, 8A refers to a piece of music that is to be regarded as national anthem if the piece of music resembles the national anthem as to lead to the reasonable belief that the piece of music is national anthem or part of the national anthem. But then, if you look at clause 3 of Trademarks Ordinance, trademarks refers to a product or service that could be identified in words or a pattern or a graphic on a similar product. Well, I remember that sounds can also become a trademark. So I want to understand if you're right saying that putting in writing and in graphics, then how come music can also become a trademark? Are there other clauses that could help you better understand it? P.S. If you have clause 3 of Trademarks Ordinance, you can look into clause 3 bracket 2. And on line 3, it says that sounds can also be treated as a trademark. Well, let's say a person uses a QR code as a trademark. And when you scan the QR code, then you hear the national anthem. So is that actually a breach of the bill? Well, this is actually a case scenario. I think the court will need to look at the QR code and what it shows when you scan the QR code, whether it's a graphic or music, and I think that the court will have the ultimate decision. So you actually do not have such a concept right now whether this would be in breach of the bill. Chairman, at this stage, we do not see this happening, so I can only make an assumption here. Next, Ms. Claudia Mo. I have the understanding that the national emblem law, national flag law, and national anthem law should all be consistent.
印象呢，就係
My overall impression is that national emblem cannot be used for any commercial purpose. National flag, if it's to be used for the design of any commercial goods, well, you can do it, but you have to apply for the use first. Well, if it's approved, then it's okay. But for national anthem, it's just a song. So the design involved is the score and the lyric. The lyrics and the scores will be the design involved. For example, printing the lyrics on a card, or the scores can be printed on the card. You said it was okay. Well, but you are talking about symbols of the country. Why do you have so different an approach? Or do you just follow the practice of Beijing, the practice of your boss? Ms. Mo, what's the relevance of your questions to the sections 12 to 14? Well, no. You look at the Section 12 is Trademarks Ordinance. It's about trade. Well, why don't you ask him to reply? Well, it has to be related to trademarks. Anything on related to the amendments to Trademarks Ordinance? I don't see the relevance here. Can you please revise your questions? No. I'm talking about commercial applications. Well, you're talking about trademarks. Why is it not relevant? Your comprehension power is really low. I cannot find the relevance to the Trademarks Ordinance. You know the Permanent Secretary is smiling. I'm not in a dialogue with you. Please specify can you ask a question that is relevant to clauses 12 to 14? I'm talking about the use of national flag and national emblem on commodities, and also whether my understanding is correct. Can you give an attempt to answer a number of questions raised by the member? Don't waste my time. The IQ is so low. Let's give the floor to the PS on commercial application. Actually, Ms. Mo asked similar questions when we talk about Clause 6. We have make reference to the National Anthem law. There's no corresponding restriction on the commercial application or commercial use of the lyrics and score of a national anthem. So we don't have such restriction here. We mentioned very specifically that the lyrics and scores cannot be registered as a trademark. But if it's a use on the commercial goods or commodities, we can only follow the provisions in the National Anthem law, and they have no restrictions, so we don't have any either. So it's in Clause 6. So do you hear it? My understanding is correct. Have you heard that we have talked about it when we had a discussion on Clause 6? Mr. Vincent Chang. Dr. Kokake. Last one, Dr. Kokake. Your time is up. We have to let the other member speak. Now that Mr. Gary Fang has also pressed the button, Dr. Kokake, well, why don't you handle the point of order raised by Ms. Claudia Mo? But this is the third time I ask you to raise questions. If you don't want to ask questions, I'll ask Mr. Fan to speak. It's a question of implementation and enforcement. Trademarks Ordinance is related to some substantive business. For example, we have trademark owners. The liaison office is an organ representing the CPG. When some video discs are produced and it's given out free or sold at a nominal price, $1 or $2, or some patriotic people might have produced a CD to sell or to distribute, which is on the national anthem. But the provisions are very strict here. If it's a sung, it can be a trademark. DAB and the liaison office and other patriotic associations made through the media of commodities such as video discs, a computer, or USB media to record the national anthem. Would it be an offense under the Trademarks Ordinance, or do they have to get some permission from the State Council or PLC? And that is okay. Is it related to the to Clause 11? Well, we have specified it very carefully here that the national anthem cannot be used in a trademark, cannot be registered as a trademark. If some people use a video or audio recording of the national anthem as a kind of a commodity, then it's not restricted. I'm not talking about commodity. Let's say the CD says it's the national anthem, and the cover is the national anthem. It may be called the trademark of national anthem. And what if the liaison office uses this? And if they do this, you have to prosecute the liaison office. If I find out that the liaison office has used the national anthem as a trademark, no one can use it as a trademark. Then Wang Chi-man may be Wang Zhimin will be in trouble. Well, he says all people, and you can give more examples. He has given you a clear answer. All people, and then you keep telling us that there are more examples. Mr. Chan Taiman, Mr. Lee Xiuming, it doesn't make any difference. Or if they are not people, well, of course, animals can then breach the law. I have nothing to add. I make it very clear. The law applies to everyone in Hong Kong. Point of order, yeah? Yes, Ms. Wu. The meeting may be aborted. The Western District will be very upset. Let's have a quorum count.
喂，請大家
Members, please return to your seats. Mr. Gary Fan, 4 minutes. Mr. Fan is not here. Mr. Wu Chi-wai, 4 minutes. I just want to confirm what I've heard. According to the Secretariat, the score of, according to the Permanent Secretary,
咧，當然係唔可以被註冊成為商標啦。但
according to the Permanent Secretary, the lyrics and scores cannot be registered as a trademark, but the same can be printed on a commodity. And first of all, we have to look at whether they have the person has done two things: whether you have altered the scores, or whether there's a playing and singing of the national anthem. If the entire score and the entire set of lyrics are included, would someone think that the presentation is sort of insulting or disrespectful? The connotation of the commodity is about disrespectful of the national anthem. I understand that it's a question about the relevance or the significance. Again, this is a scenario question. We have to go back to clause 7. When the score and lyrics are used in a certain way, whether it's a commodity or not, if it's publicly made, if it's intentionally about insulting the national anthem, then it's an offense. I just want to give you an example. Let's say I have a piece of paper towel and something is printed on the paper towel. The total score and lyrics are printed. It's a paper towel. What the producer of the commodity or the people who use the commodity would have the intention judged by the court to see whether there's the necessary intention. I have to remind members that this amendment is only about the empowering the registrar of trademarks to refuse the registration of national anthem scores and lyrics as trademarks. Mr. Gary Fan, I'm concerned about clause 13. It says section 11 amended. Absolute grounds for refusal of registration. So absolute grounds, what do you mean by absolute? What's the legal significance of the term absolute? Because section 11 is about application of laws of Hong Kong. Would this be related to the investigation, prosecution according to the laws of Hong Kong? If we take away the word absolute, would it make any difference? If there's a difference, what's the difference? Well, absolute means there's no discretion.
Yes. Thank you, Mr. Fan, for your question. The title for Section 11 is absolute grounds, whereas in Section 12, it's relative grounds. I think the absolute grounds in Section 11 refers to the trademark itself, and in Section 12, we're looking at whether or not registered trademarks conflict with existing trademarks. So there are two different grounds for rejection. Mr. Gary Fan. Dr. Cheng Chung Tai, 4 minutes. Thank you. I think the major amendment is to add provisions in the trademark ordinance, which is namely the part about the national anthem ordinance. What is most difficult to understand is that in the trademark ordinance, section 3, bracket 2, we were saying that when we try to, the national anthem could be, represented by song, musical notes, the score, and the lyrics. So section 3, bracket 2 of the trademark ordinance says, without contradicting the principles in section 1, the following would be the various, groups of trademarks. And based on these absolute grounds, these trademarks cannot be registered. The question is, under the national anthem law, how do we understand without affecting section 1? Section 3, bracket 1 of the trademark ordinance says that in this ordinance, the trademark refers to anything which can differentiate the product of an enterprise from those of other products. So there are two important parts here. That is either in the form of text or in pictorial form. Whether or not it relates to an enterprise is something else. The PS, in replying to Mr. Ray Chan's question, said that section 3, bracket 2 follows the principle of without affecting section 1. Still, you're not able to convince everyone as to how the song, I think based on section 3, bracket 1, I think symbols, represented by, text or song. I don't know whether the PS understand the relationship here. In section 3, bracket 2, of course, song is relevant, maybe perhaps not older. And then you will invoke section 3, bracket 1, the general principle. But what about trademarks represented by songs or pictures? So we may need to further, this is an area where we need further interpretation. I understand your question, but I don't see the relevance. But anyway, the PS, perhaps you can try to answer the question. I would like to explain, section 3, bracket 2, without affecting the generality of section 1. I think this is a very common drafting method. Section 3, bracket 2 is about the definition. So it explains what is a trademark. Section 3, bracket 2 says that the trademark can contain such words and other things. It is saying that even if these things are listed under section 3, bracket 3, it will not affect the general, definition in section 1. The general definition still, stands, except that section 3, bracket 2 would say that trademarks could cover all those things. So my question is this: since the national anthem could be in the form of, text, sound, and so on, under section 3, bracket 1 and 2, section 3 is about sound. How is that interpreted in section 3, bracket 1? 3, bracket 1 is a general description. Section 3 expands that. Ray Chan. I would like to refer to the point that songs could not be used as a trademark. Now, I think the court has rulings regarding, whether people actually plagiarizing, or if you only copy a few bars of somebody else's song, you may not be guilty of, infringement of the other party's copyright. How does the trademark office make that judgment? Of course, it has the discretion. If he feels that it's part of the national anthem, or it sounds like the national anthem, or people will associate that with the national anthem, then it will impose an injunction. We talk about, for example, the song by Hacken Lee, Football Carnival, and so on. So in the entire song, part of that maybe of the few bars in the lyric in the score resembles the national anthem. I also like to know what is the consequence of violating this section. Is it that it will not be able to register anything which breaches Section 13? But if the registration were made overseas, would you hold them accountable? If they registered that overseas and sell the product in Hong Kong or distribute that in Hong Kong, would there be a legal consequence? I think this question has been raised before, especially when we deliberated on Section 8. P.S. The Trademark Registration Office duty is to determine whether certain things could be registered in accordance with the law. According to the National Anthem Bill, we already clearly define what is the National Anthem. So, of course, the Trademark Office will have to make reference of the Trademark Ordinance when enacted. Section 11 only explains that the following trademark cannot be registered. The consequence is that if you have all these elements, then it cannot be registered. So it cannot be registered, but there is no legal risk. And would there be any indirect legal risk? Let's say trademarks registered abroad and the product is distributed in Hong Kong using this as a trademark. It doesn't, it's not a question of, of the trademark registered in Hong Kong. Well, the consequence is that trademark cannot be registered here. So there won't be any other legal consequence. No, I don't have anything further to add. Claudimo, 4 minutes. Thank you. If somebody has not registered a trademark and he just doing it for fun or whatever, let's say the March of the Volunteers, those words, he would put it in his trademark. Does that mean that there was no consequence if he did that? It has to do with registration. I think that question has been answered. I think the definition of national anthem law is already provided for in Section 8. The name of the national anthem is not contained in Section 8. What about the symbols, the lyrics, the scores, which if it were used as a trademark? I haven't asked that question. I'm talking about trademarks now, not commercial products. Well, according to Section 11, it can't be registered. I know, but if somebody, do it anyway, will he be arrested? Well, again, one would need to look at Section 6 and 7 to see whether he has breached the relevant sections. So that means you're not able to answer the question. In 13(3), you say that Section 11(9) means that the national anthem and so on, you're talking about the number of strokes of the characters will be counted. For example, the Chinese word "guai," the traditional version contains many strokes. The simplified version contains far fewer strokes. So we do have the approach of following the number of strokes, and we would adopt the traditional version. Well, in Chinese, you say it's determined by the number of strokes, but in English, you say in alphabetical order. Why won't you say according to the number of strokes and proper Chinese characters? In that case, that would be the Chinese and English version would match. But in the legal definition, there is a definition in the Chinese and English version. In the Chinese version, it says based on the number of strokes. So if somebody doesn't know English, reading the Chinese version, he can, find the Chinese definition based on a number of strokes. Whereas in the English version, one can find the definition based on the alphabetical order. So I understand. So when you draft any piece of legislation, this is the common practice. It's not that A, B, C would mean number 3 in Chinese. So in terms of when it comes to the interpretation, yes, KK Kwok. 3 minutes. Now, for the national anthem being used as a trademark, so if it is the text itself, we can understand. Let's say the liaison office or the DAB, using the national anthem as a trademark, right? To show the loyalty and patriotism, right? But what about sung? Say after the national anthem is being sung. So if the song is used as a trademark, does it mean that if after somebody has sung the anthem, and then he would show a product and trying to create the impression that the product is somehow associated with the national anthem? So how do you prosecute if somebody used the national anthem, the song of the national anthem, as a trademark? Well, I think this point has been raised before and this morning as well. Chairman, it's not that I'm not allowing this question, but this morning we already have 2 other questions of the same nature. Chairman, Section 8A already sets, it refers to the score. It said whether or not so song could constitute a trademark and registration may be rejected. And regarding product, we already answered the question earlier. Chairman, in the trademark ordinance, there are very stringent rules. For example, there is a section about there's some stringent legal procedure regarding infringement. Now, in future, if the trademark ordinance, now if people are not allowed to use the national anthem as a trademark, so if somebody use the national anthem as a trademark, would that be treated as a violation of copyright? In this case, is the SAR government or the central government or the liaison office, which will be, the party concerned. Of course, the trademark ordinance is a local ordinance. Of course, the law enforcement authorities in Hong Kong will do it. So the SAR government will prosecute the culprit on behalf of the CPG, right? It's not a question of, acting on behalf of the CPG, because if we're talking about local legislation, the law enforcement in Hong Kong will enforce the law. Can the liaison office initiate prosecution? They can only report the offense, but they cannot prosecute, right? Chairman, I think we've answered that question many times already. Everyone has to, obey the law. I've also said once, and I'd like to reiterate again, that we are looking at Section 12 to 14, which is about the consequential amendments. We are not discussing questions of infringement and violation of the trademark ordinance. The only purpose of Section 13 is to authorize the Trademark Registration Office to reject any registration. It is about the absolute grounds for refusing to register the national anthem as a trademark. So it's as simple as that. And it's the sole purpose of Section 13. Mr. Kong Chun Yu, thank you. First of all, I think we really need to clarify things which are related to trademarks. Earlier, I said that the definition of trademark is very wide. It refers to different products and services. It could be it could be in the form of a text, an alphabet, a picture, a sound, odor, the shape of the product and its packaging, or any combination of the above. And that it could be presented in textual or pictorial form. I'm sure that our colleagues from the Bureau has made reference of that. I think the intellectual property divisions has already told us that even odor could be part of a trademark. So for sections 12 to 14, we are talking about CAP 559, the Trademark Ordinance, namely the absolute grounds for refusal of registration. Now, if the words trademark has such a wide definition, I still like to go back to the question, that is whether there would be a scenario where people may inadvertently break the law. That is, let's say somebody registers something as a trademark and I think it's sort of a borderline case. We don't know, of course, whether this will really take place. But in future, we have many legal litigation involving trademarks. There was one shop which was sued because, it made some artifacts using certain elements of a prestigious brand. So as a result, the proprietor of the shop had to apologize. And so what I'm saying is that if somebody could successfully register a trademark using the lyrics of the national anthem as his trademark, so how will you deal with the already registered trademarks? If you're looking at a borderline case and subsequently you would say, well, you want to prosecute. So will this happen, or can you guarantee that this will not happen? Permanent Secretary, you can perhaps answer the question, but I don't understand what he means by substantive, situation. But if you understand the question, please. Well, Section 6 already said that the lyrics and the scores of the national anthem cannot be used in a trademark. As for the existing trademarks, I don't believe that it could be registered if it contains elements of the national anthem. Last time we checked, there is none. Whether or not there has been any since the last time we checked, perhaps we can check again. But any trademark which breaches the law cannot be registered. I don't think you should be too confident. I was talking about borderline cases which you may only subsequently discover something is wrong, or perhaps a person doesn't know at the time of registration. I think similarly, if somebody successfully register a trademark and containing those elements, and you discover afterwards, so what are you going to do? Are you going to revoke that trademark or what? It's hypothetical. Normally, we're not talking about the national anthem. If you could successfully, slip through the net, then somebody, of course, may complain afterwards, and the trademark registration office may subsequently revoke that trademark. I think in China it's a very common practice that people can try to register trademarks using such tactics.
Dr. K.K. Kwok. If a person has already registered for a trademark outside of Hong Kong, then what would happen? Let's say this person registers the national anthem as a trademark in Latin America. Well, this question has already been asked. P.S. please. Well, we're talking about legislation in Hong Kong now, so it's not valid in Hong Kong. All right, the trademarks ordinance is in accordance with the Paris Agreement. But what we are doing here right now is not directly related to the industrial movement. I want to ask, aside from mainland China, would any other country make the national anthem as a trademark? Well, I want to see whether that is in breach of the Paris Covenant. Well, it is. Do you know which which article? Well, there have been a few amendments. The first amendments were on March 20th of 1883, and then there were other amendments along the years, and the latest agreement signed was in 1985. I don't want to know the history. Well, you're asking me to tell you. I'm talking about the Paris Agreement. Well, so why don't you call a quorum? Because nobody can answer this question.
夠啊？係咪夠人啊？請你回答郭家麒議員。
Please answer Dr. KK Kwok's question briefly. So, is Clause 13 in violation on the Paris Convention for the Protection of Industrial Property? Well, any will need to draw on local legislation on any convention, so I'm sure that there will not be any breach. Can you provide me with more information after the meeting? What kind of information are you looking for on Hong Kong abiding by the Paris Convention? You mean on trademarks? You mean in relation to Clause 13? Yes. On Clause 13, whether there is any breach of the Paris Convention. We can ask the Registrar of Trademark to provide you with more details after the meeting. Thank you. Mr. Ray Chen. Well, Clause 13 and Clause 13 both include a part on a bracket of 2019. So, what number would that be? Would it be after the third reading? Or let's say, well, it's a very small possibility that it's not going to pass. But what if it happens? Would it still remain as 2019, or would the number be actually for the year after if this could not be passed this year? Your understanding is correct. So when this becomes a legislation, so we would look into the number which is gazetted. Or let's say if it cannot become law by 2020, then when we gazette it, then there would be a procedure in which we could amend the year. Okay, thank you. Dr. KK Kwok. 1 minute. Chairman, I'd like to ask about the legal basis. The Schedule 3 has to we talked about how we apply or adapt the national anthem law to our bill, but then we didn't mention about the trademarks ordinance. So that means that we are a bit overdoing it. So the national anthem bill, the clause 8 of that, or article 8 of that, should we actually follow that standard instead of going overboard? P.S. If you look at the Article 8 of the National Anthem Law, I don't understand, because there's already this requirement written in Article 8. No, I see in Article 16 of the National Anthem Bill, there is no mention of the Trademarks Ordinance. Yet here we have made it very clear that there is to be amendment made to the Trademarks Ordinance. I don't see any mention of the Trademarks Ordinance in the National Anthem Law, so that is the reason I'm asking this question. Well, Trademarks Ordinance is actually a local legislation. Also, you're saying that, please do not talk between yourselves. So you're saying that there could be a breach of intellectual property on the mainland. Mr. Gary Fan, I would like to ask Mr. Pang right now. Just now I asked about the absolute grounds for refusal of registration. Well, because 13 is actually on the amendment of Section 11, and therefore there is absolute grounds for refusal of registration. But then it should be consistent with the Clause 12, that it should be amended as set out in the divisions in Division 2 and 3. Well, can you explain it further? Well, I do reference from the intellectual property rights, because we're saying whether there would be a refusal of registration because of the trademark. And when the trademark being brought in for registration, would it actually be similar to an already registered trademark? So due to those reasons, then that could not be registered. So there are two different categories here. Well, how about leading to reasonable belief or copying, or when you're talking about being a relative? Is that my understanding is correct? Well, yes. We use that to differentiate the differences there. Mr. Gary Fan, sorry, I need to sort of digest this information first. Well, should I allow another member to speak first? Yes. Ms. Claudia Mo. 2 minutes. I have a query out of curiosity. Clause 13 bracket 2. We're just talking about punctuation here. Here it says section 11 bracket 9 Chinese text definition of guok kei and guok fai. It says to repeal the full stop here. If I look at the term Chinese 廢除. Well, I think you can just say you take out the full stop. You can use a delete. Why do you have to use repeal? So repeal has actually close the meaning of a revoke and annul. This is only a punctuation. Why do you have to use such a heavy word? Why can you just put delete, 刪除? Or is it you have to sort of use this formal wording because there is a formal practice? Law draftsman. Well, when we make textual amendments, when we need to add or delete certain terms, we do have our practice of what words to use. If we want to put in, then we say add. If we want to take out something, we use the word repeal. So that would be consistent with our wording. So we use a repeal for anything that we want to delete. So it could be punctuation or any words. So that's actually the way, or the formal way of the formal practice. Yes. Dr. K.K. Kwok. The amendments made to the Trademarks Ordinance, that we also draw reference from the Patents Authority in China. Well, because in Hong Kong we have the Registry of Trademarks. Well, how about for China? So is it a Patents Administration? So are there similarities between the two? Well, our objective here is to try to be consistent with the national law. So we want to know what the other side is doing. Well, in accordance with the trademarks ordinance, if we use the national anthem as trademarks, then the registration will be made invalid. So that is what's happening on the mainland. So it is inconsistent with the trademarks ordinance in Hong Kong. All right, we do not have any further questions for these clauses, and we have completed our clause by clause scrutiny. The next phase will be to look into CSAs, but members from these Conservative Party and also from a Democratic Party, and also Mr. Gary Fan and Ms. Claudia all moved CSAs. Some of the CSAs we have received replies from the administration, yet the others, the administration still hasn't given any responses. So I would like to wait till we receive all the government responses and then to go through the CSAs in one go, because some of them may be repetitive. For example, delete clause, repeals clause 7. So these have been raised by many members. Mr. Gary Fan, so would the government provide us with a response before the next meeting and not be tabled at the next meeting, because we do want to have time to prepare for it. We're only going to discuss responses given by the administration, and there would at least be 2 days of preparation for members. But for parts that the government has not yet responded, then we would discuss those that we have already received answers. Rules of procedure. Yes, I'd like to ask the law draftsman or the administration. Well, we have already, for some of the CSAs, you have already given replies, but some you have not yet had the time to do so. Well, we now are concerned with the time. We do not want the government not having enough time to respond to our CSAs. I don't think this is an ideal situation. So I want to ask the administration. I think the deadline for CSAs is the 20th, noon. So how much time do you need to provide us with all the responses?
Okay, as you have suggested, we can discuss those CSAs for which the administration has provided its response. There may be more than one such meeting. Dr. Kwok, can we allow the administration to indicate the time frame involved so that we can get prepared? The Secretariat has invited members to submit CSAs by noon, the 20th of May. So we can provide a response by noon, the 23rd of May. We may not be able to deal with all CSAs in one meeting. We have some from members of Democratic Party. The response has been provided, so we can talk about those. And for other CSAs, we can wait until there's a response from the administration. We would then convene another meeting to discuss those other CSAs. Mr. Kwong Chun-yi. Chairman, I'm one of those who have moved a CSA to repeal the Clause 8.
Major sports events.
During sports and major events, the national play is to be played. National anthem is to be played. I believe there will be other CSAs for which a response will be provided from the administration. So my concern is that, well, we are against any decision to draw the line by you, Chairman. What are you going to deal with CSAs? We're going to have more CSAs. Would you draw the line on the discussion of CSAs before the administration has provided a response? I'll exercise my discretion if that happens. This is not a point of order, Mr. Huang. It's not a point of order. Mr. Elvin Young and then Mr. Chan Chi-chin. As a question, 4 members of a civic party have proposed some CSAs, 4 CSAs. on the 15th. Those have been referred to the officials. Mr. Chen Chi-chen, I heard from the Permanent Secretary that by noon 20th of May, we would be required to submit the CSA, so that would be the line. Then they would provide a response by the 23rd of May. And you talk about that you allow some days for us to look into the response. Would there be a clash with the PWSC and the National Anthem Bills Committee? You know what you want to propose in your CSA, and you don't need a lot of time to digest the reply. If I say we need 5 days, I'll allow 5 days. If I think 1 day would be good enough, it will be 1 day. You are the ones who propose the CSAs. You know very well what they are about, and the response I don't think will be very complicated. You have mentioned that we have frequent meetings. We have to accommodate the availability of officials. There's nothing we can do about that. We would we'll give sufficient notice under our rules. Can you promise us that this will not clash with the PWSC meeting on the 25th? Why? I cannot give another ticking like that. You know that we are so busy. I've already said that this is not something I want to see, but I cannot avoid this. If we have to avoid any clash, then this meeting will not be able to have more this Bills Committee will not be able to have any more meetings. Can you promise that it will not be on the morning of the 25th of May? I'm not talking about their availability, but whether we have sufficient time. The reply will come on the 23rd of May. Well, that depends on the reply from the administration. Please let me finish. I would like to remind members that if you want to move any CSA, please do so by noon. Next Monday, the 20th of May, please deliver your CSAs to the Secretariat for onward transmission to the administration. AOB? Nothing under AOB. Meetings are now adjourned.